Settling an estate. How courts determine whether a will is valid. The heart of every estate plan is a will, also known as a last will and testament. This legal document puts you in control of who inherits your property and who will take care of your children if it were ever necessary. Without a will, state law determines these issues through the probate process. With a will, you can also name an executor or personal representative to carry out your wishes, and it can appoint a trusted person to manage property left to young people. Watch this video to understand the fundamental requirements of a proper will before relying on it to wrap up the estate. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about selling an estate, how courts across the country determine whether a will is valid. Let's talk about the basic requirements of a will. To be legally binding, a will must meet 3 requirements, all intended to protect against fraud or forgery. So the will must be in writing, signed and dated by the person who made it, and signed by witnesses. If a will seems to have been properly signed and witnessed, chances are the will be validated. You have no responsibility to investigate the circumstances of the will's signing unless someone suggests that there is a problem. The major exception to this rule is that in about 50 to 55% of the states in the United States, a handwritten, unwitnessed but signed will is valid if it's clear that it was really intended to be a will. So I'm talking here about 26 to 28, 29 states. It's also important to understand that certain circumstances can affect the will. For instance, family changes. The will maker's divorce or marriage can have a dramatic legal effect on the terms of a valid will. Wills generally cannot dispose of property that's held in joint tenancy or in a living trust, or for which a beneficiary has been named in another binding document. We have an entire show on joint tenancy, so you really want to check that out. You will learn a lot about joint tenancy, what joint tenants are, what they do, and what are their rights and their responsibilities from a legal standpoint. Even if a will that's properly signed and witnessed even a will that's properly signed and witnessed may be open to challenge. Let me give you an example. We can have the ground that the will maker did not have the mental capacity, perhaps because of Alzheimer's or another illness, to make a valid will. So people can go to court and say, you know what, this will is not valid because the will maker, was not mentally sane, mentally sound. Let's talk now about writing. As I said earlier, for a will to be valid, you have 3 requirements. The will must be in writing, signed and dated by the person who made it, and signed by witnesses. Let's first talk about writing. These days, most wills are generated on a computer and printed out. Older wills were generally typewritten. A will may also be entirely handwritten as long as the signature and witnessing requirements that I will talk about soon, as long as those witnessing requirements are met, everything is fine. But a mix of machine-generated printing and handwriting can be legally troublesome. For example, if something on a typed document is crossed out or added by hand, it is virtually impossible to tell whether the change was made before or after the document was signed, or even who made it. A minor handwritten change, or one that all inheritors agree to. For example, a note added to an existing will after a grandson is born, leaving the new baby $100,000. If you have such a minor handwritten change, or again, one that all inheritors agree to, this is not likely to be a problem because everybody is on board, everybody is comfortable with it, it's fine. But if the change is major and may cause disagreement, for example, let's say you want to remove, let's say the will says a beneficiary must be removed entirely. You want to really see a lawyer because this change is again major and could cause a disagreement, you want to see a lawyer ASAP. So writing is the first requirement of a valid will. Let's talk about signature and date and electronic signatures. The person who wrote the will, in legal terms, is called the testator. The testator. So the testator must have signed and dated it at the end of the document. So if a will maker who was not physically able to sign directed someone, for instance, to sign for him or her in front of witnesses, that counts as a valid signature. The signature does not have to be notarized. States are very clear, and courts have made it clear in the last few years that in the probate process, signature does not have to be notarized. No, it is common but not legally required for the person to also have initialed each numbered page of the will. Again, here we're talking about the testator, the person who wrote the will. What about electronic signatures? The law on electronic signatures and wills is still up in the air. Legislators across the country are still debating that particular aspect of things, and hopefully in the next few years we will have some clarity over that aspect of things. In at least one case, there was a court in Tennessee that accepted a will signed not with pen and ink but on computer. What happened was a man wrote a one-page will on his computer, asked two neighbors to witness his signature, and then in their presence added a cursive version. The case is called Taylor versus Holt. This was tried in 2003. So this was, and again, the case was in Tennessee. So what happened was the witnesses then signed the paper. The Tennessee court ruled that a signature included any symbol or methodology by a person used by a person with the intent of authenticating a document. So they actually approved it. They accepted it. Now, having said that, this is a one case that's not applicable to other jurisdictions in the country. As I said earlier, things are still murky here. Things are still gray here. We have a gray legal area, and it will be wonderful for our legislators across the country to move on really fast on that issue, because every year we have several hundred cases that linger in the court system simply because the law on electronic signatures is not really clear as of now. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic and you are enjoying this show. I want to talk to you now about witnesses. So we talked about the fact that the will must be in writing, must have been signed, and also must be signed in the presence of witnesses. And why do we have witnesses in the first place? This is a protection mechanism against fraud and forgery. So almost every state requires the witnesses, as well as the will maker, the testator, sign the will. If the witnessing requirements were not met, the probate court judge will decide whether or not to admit the will to probate. Keep in mind that judges take these rules quite seriously. At least two competent witnesses must have signed the will for it to be valid. In the majority of states, the witnesses must have both watched the testator sign the will and then signed it themselves. And there are a few states where it's enough if the will maker told them his or her own signature was valid and asked them to sign later. An important element to remember here is that the witnesses don't need to have read the will, but they need to have known that the document that they watched being signed was a will. They have to be cognizant of that. There are a few things that courts pay attention to when it comes to validating witnesses and their signatures in the probate process. Age of the witnesses. So witnesses must be legal adults, 18 years or older. If any of the witnesses are under 18, the will is invalid, is not valid. Witnesses who inherit under the will. In most states, someone who stands to inherit property under a will may not be a witness to it, which makes sense. In these states, if a beneficiary signs the will as a witness, and there aren't enough other disinterested witnesses, the general rule is that the gift to the witness is canceled. The rest of the will remains valid though. If you face this situation, it's always important to ask a lawyer and also look up your state's law on witnesses. We also have another element to pay attention to: notaries as witnesses, the use of notaries as witnesses. Wills do not need, as I said earlier, do not need to be notarized. But some people get wills notarized anyway. You can't force them. It's their decision. Usually, if there is a dispute over witnessing, the notary public counts as a competent witness. For instance, if only one person signed as a witness, or one witness was disqualified or died later, but the will was notarized, the notary would be counted as the second witness. Let's talk now about lawyers as witnesses. Can they be witnesses? Normally, it's not a problem if the attorney who drafted the will also serves as a witness. This is true even if the attorney is appointed executor and so stands to benefit by collecting fees for serving as executor from the will. Courts have been very clear about that. It's not a problem. Lawyers can serve as witnesses. Notaries can serve as witnesses. Of course, as long as they do not inherit under the will and they are 18 years or older. Let's have a quick conversation about out-of-state wills. You might find that the will was signed in a different state from the one in which the person was living at the time of death. Again, we are in the United States of America, so it shouldn't be a problem. We are a one country. Generally, if the will was valid under the laws of the state where it was signed, the new state will accept it as valid. Not a problem there. What about handwritten wills? If you find a handwritten will that was signed in front of witnesses, the will is considered a regular will and is treated just like a typed one. However, if you happen to find a handwritten will that was not signed by witnesses, you will need to check your state's laws, and state laws are kind of divergent on that matter. Those handwritten wills are usually called holographic wills. So such holographic wills are legal in about 50% of the states if they are signed and all of the important provisions are in the writer's handwriting. Some states require that they also be dated. What about a pre-printed will form on which the will maker has filled in blanks in handwriting? Some courts have considered these documents to be holographic wills. Some haven't, so the jury is still out on this matters. Even in many states that do not allow holographic wills, a will that was a valid holographic will when it was made in another state will be considered valid. So the point I'm trying to make here is that you always want to go back to the three basic requirements that I mentioned earlier. It has to be written, it has to be signed, and it has to be signed, it has to be dated, it has to be signed in front of witnesses. As long as you have those three elements, whether the will is holographic, quote unquote holographic, or not, whether the will was signed out in another states, it shouldn't matter. Because even though the laws, when it comes to probate, when it comes to estate planning, when it comes to wills, are a little bit different across the 50 states, you have some kind of uniformity. There is some uniform set of laws that make it easier to move on, regardless of where the will was first signed. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic. I'm doing marvelous. We are still having a conversation around selling an estate, how courts determine whether a will is valid. We've talked about out-of-state wills, handwritten wills. Let's talk now about videotaped wills. Folks, this is clear, and I want you to pay attention. Video wills are not valid. They are never valid. Don't even try to do it. Don't even do it. Courts will not accept it. What if you have more than one will? It is common for people to make several wills over their lifetimes, changing the terms as they marry, divorce, have children, acquire different assets, or suffer the death of a spouse. So if the deceased person did not get around to destroying old wills, you may find more than one. Generally, the most recent will supersedes the earlier ones. In other words, the courts will validate the most recent will over the earlier ones. In fact, it is a standard practice for a will to include a statement revoking all previous wills and codicils. Even if a will does not expressly revoke previous wills, it may revoke them simply because it contradicts them. If a more recent will is inconsistent with an earlier one, the law generally follows the wishes expressed in the more recent document. Even if you're pretty sure that an old will has been superseded by a newer one, you want to hang on to the old documents. If the later one or part of it turns out to be invalid for some reason, you may need the old one. So the idea here is to start being very clear in all your wills. And if you have several wills, do not destroy any of them. Just make sure that the most recent will conveys as clearly as possible, as loyally as possible, your wishes, your last wishes, if you will. And if something happens, the most recent will is not validated by court, at least you have a backup. You have several backups for that matter. And this is the idea here. And videotape will, forget about them. Don't use your smartphone, your phone, just to record a will. It will not be validated. All right, folks, this is the end of today's conversation. I was talking to you about settling an estate, how courts determine whether a will is valid. And here's a recap. I spoke to you about the basic requirements of wills, spoke about writing, signature and dates, spoke a little bit about electronic signatures, witnesses, the importance of witnesses. I also talked to you about out-of-state wills, handwritten wills, videotaped wills, and situations where you have more than one will. Of course, it's also very important to understand that we're not offering any kind of legal advice here. It's better to reach out to someone who is well versed in the subtleties of estate planning in your state, a lawyer, an attorney. Your situation is different. Everybody's situation is different. So you want to reach out to an expert if you require the services of one, and he or she will help you draft a will that has a higher chance of being validated. Another thing you want to pay attention to is to always keep your paperwork. Doesn't matter if you have 2, 3, 4, 10 wills. Always keep your paperwork. Always keep your paperwork, your papers. You never know. So if stuff happens, you can go back and use the old documents. We have an entire show revolving around financial and legal papers and how to store them, how to save them, how to preserve them. You might want to double check that show. All right, I will see you next time. But until then, remember, stay marvelous.